Good morning. We're sorry to have detained you a few minutes. Yes, Mr. Harwood.
My Lord, this matter I appear for the claimant and the Appellant Spitalfields Trust. My learned friends, Mr. Philpott and Mr. Fore, appear for the local authority, and on my far right, Mr. Corner and Mr. Vandermill appear for the second respondent, who are the developer. The court should, I hope, have a core bundle and a supplementary bundle, and a bundle of authorities.
Yes.
Also a bundle of unagreed material, which relates to other council constitutions.
Yes.
The court may have spotted that that material is incomplete, in that what the application was to put in was an Appendix C from Mr. Philpott's skeleton.
Yes.
The court only has the first page of that appendix. There are two further pages. So if I can pass up...
A three-page document is here.
You've got it, thank you. So, my Lord, should be everything which the court needs to have.
Yes.
My Lord, if I can go, leave it in the court's hands how you want to deal with those other constitutional extracts. Seemed our central point was that they don't really take us very far at all. But
Well,
we take time.
We don't want to take time on objections to admissibility and so on. If somebody wants to show us what goes on in another authority, it may or may not help, but we'll just take it as it comes.
My Lord, I'm content with that. My Lord, I'm going to go straight into the case, and the issue is a point of law, whether there is the power for a council to make standing orders to prevent councillors who are members of a council committee, in this case, a committee subject to political proportionality requirements, but prevent members of a council committee from voting. It is simply a vires point whether there is a power to make standing orders to prohibit members from voting. And we make 3 points. Firstly, there is an explicit statutory right to vote in these politically proportionate committees under the Local Government and Housing Act 1989. I take the court to that in due course. Secondly, it is in any event implicit, at least in the legislation, that councillors are entitled to vote, and councillors who are members of committees are entitled to vote on those committees. And the third point, and this is the point of contention, I suspect, is that the rights conferred by the legislation to vote cannot be overridden by the council's own rules or its own decisions. Where the right to vote is removed, it is removed by the legislation. Now, my Lord, as part of the context is this, that we are not concerned with the particular circumstance and the way in which this particular rule is in place. We do accept that if there was a power to remove councillors' right to vote by standing order, then there must obviously be some circumstances in which that power can be exercised. And it would not, in principle, be irrational in the extreme Wensbury sense, that no public authority considering the matter could decide to do it. It would not be irrational to have a rule of this nature. But simply there is no power to have such a rule. Parliament has decided when members can or cannot vote. But another point goes into context. Leaving aside the constitutional prohibition, it would not have been unlawful for a member who wasn't at the first meeting to then vote on the application at the second meeting. Neither is there in law a prohibition on him doing so, or her doing so. But also, were they to do so, would not render the decision of the committee unlawful. Committee members, of course, have to have regard to all material considerations, and that may affect the lawfulness of a decision. And we'll come to one or two of the cases on the basis of these issues, where members might not have seen the site, or might have missed some of the debate. But in the present context of the rule of two meetings, it is perfectly practical for any member who wasn't at the first meeting to be sufficiently informed to make a decision at the second. First of all, what happened here and happened regularly is that where an application is deferred, then the original report is appended to the report which goes to the second meeting. If that doesn't happen, then the original report, there's a report which brings together all the material to do that. If there really was, for example, something said at the first meeting, then that a member later on would need to know, then that can be contained in those reports. Were it to come to it, given that it's all these days recorded and webcast, members could be shown a transcript or even asked to be part of it. So there's no difficulty in public law terms in a member not being at the first meeting, being at the second, and then making a decision. So, my lords, whilst if there was a power to restrict the right to vote, this situation of two meetings on the same application that gets deferred might be a rational situation of bringing such a rule in. If you don't have such a rule, it doesn't, not a situation where the second decision would be one which is liable to be found unlawful through a failure to have regard to material considerations, for example. My lords, I was going to really say next to nothing on the facts because I hope that those are clear enough from the skeletons and from the judgment below.
I think that there's a lengthy narrative in the judgment of Mr. Justice Morris, and as I understand it, nothing in that narrative is questioned by anybody.
No, my lord.
So we can gratefully adopt it, as the saying goes. Yes.
Yeah. And the court will have seen in this situation the fact that only 3 members were able to vote at the second meeting when there were 4 other members who could have either attended or been brought in as substitutes, mean that this rule potentially affected the outcome. And so for those reasons, and it's not disputed by my learned friends, if the appellant is right, that the rule is unlawful, then the outcome may well have been different.
Can I just ask, so that I'm clear, the 4 members, the last column in your table,
Yes, my lord.
none of them were there?
None of them were there, my lord, and
So they couldn't have voted?
they weren't. They weren't there. 2 of them were members of the committee. Sorry, I think correction. Yes, two of them were members of the committee, and 2 of them were substitutes. The only substantive item which was on the committee agenda was this application. The only other items were the approval of the minutes of the previous meeting, and then there's a standard item on procedure, but that is simply procedure for the meeting. It's the same every time. It's not the council weren't making a decision on their procedures and cases going forward. So, from a member's perspective, the only thing that remotely mattered on that agenda, the only possible reason for going to the town hall for that meeting would have been this particular application.
Yes.
But
So
they wouldn't have been able to vote under the rule because they hadn't been present in April.
That's correct, my lord.
So you're saying there would have been no point in them turning up?
Indeed.
Unless it was to observe. They couldn't have taken part in the discussion even, is that right?
They could have taken part as a member of the committee. Yeah.
I only asked that because on the transcript, Councillor Qureshi, it appears to think even at the end of the meeting that she can vote.
She couldn't.
Clarity is not the watchword of the transcript, I quite accept, but there is the position even in relation to her, and I know that no issue arises in relation to her, but was not clear cut. So the 4 councillors who didn't attend, they didn't attend because they knew that they couldn't vote?
Well,
Unlike Councillor Qureshi, who seemed to think she could?
my lord, there's no explanation from those as to why they didn't attend.
Right.
So we don't have that. The obvious explanation is, and the reason why the substitutes weren't deployed, was because the council rules said that they weren't able to take part and vote. And my lord, there's no dispute from the court's conclusion below that this may have made a difference, that had the rule not been there, the committee would have likely either been 4 or 5 members, or even with 4 members, given that the chair was against the scheme and would have had a second vote in the event of the votes being equal. The addition of 1 or 2 members could well have changed the outcome.
Yeah.
In terms of Councillor Qureshi, her problem was a separate one, which is that while she was present at the first meeting, which took place under the coronavirus rules, which allowed virtual meetings, those rules had expired at the start of May that year. The Divisional Court had since ruled around the same time that when you go back to the existing legislation and it's Schedule 12, paragraph 39 of the Local Government Act, present and voting, that present in that context meant physically present at the meeting. So the reason Councillor Qureshi wasn't able to vote was because she was observing remotely.
And no issue arises as
I
to
think,
that.
yes, and I think that was COVID isolation. I do think that's in the material. But
Could she take part in the discussion, however? Was that caught by paragraph 39?
Paragraph 39 wouldn't prohibit her from taking part in the discussion because it's a requirement to be present and voting.
So the only restriction was that she couldn't vote because she was online and not physically present in the committee room.
And there's no difficulty in any event of members who are members of the committee taking part remotely. So the ward councillor can make representations online in the way that objectors and developer can and very often do.
Well, I hesitate to rise, but just for clarity, the 11.4 rule is only relating to voting. So only those present at the previous meeting will be able to vote. It's voting rather than simple participation.
So would that have applied then to the 4 councillors in the final column in the table? They could have taken part in the debate, but not voted.
That's my understanding of it.
Councillor Qureshi, if she had been physically present at the September meeting could have voted.
That's correct, my Lord.
Right. But she wasn't.
That's correct.
Now, suppose that after some discussion at the September meeting, Councillor Muckett had got up and walked out. What would have happened?
That would depends what the quoracy rule is, and my Lord, we may be able to, between us.
I thought the quorum was 3.
Yeah, if the quorum was 3, and there were only 2 councillors left in the meeting who were able to take part in that, then the meeting at that point would become in quorum.
And the application would have to start again, wouldn't it? Because the committee could never be quorate, because the meeting 1 reduces the constituency to those, the constituency, I'll call it, the people eligible to vote were 4 in September, because there were only 4 survivors from the April meeting who could have voted had they turned up. But Councillor Qureshi, by not turning up at the September meeting, disqualified herself from voting at that meeting and at any subsequent meeting because of the operation of the rule. And if Councillor Muckett had walked out, then that would have been the end of it, and the application would have had to start again, wouldn't it?
Well, the meeting would have ended. The application would have then had to come back to another meeting of the council.
Lord, again, if it helps, that the Rule 11.4 provides if this renders the committee inquorate, then the item will have to be reconsidered afresh. So my understanding is the same as your lordships. In those circumstances, it would have to go back to the beginning again.
Yes. I mean, the scheme might in the end have been approved, but it would have had to start again with a freshly constituted subcommittee.
Well, if on the inquoracy rule, it may be helpful just to turn up the 2 particular rules. So if we go to first of the rules, which are in the supplementary bundle 610.
Mr. Harwood, would you just give me a moment?
Not me. I haven't got it.
Oh, just a minute. Is this yours? I've been given Lord Justice Coulson's core bundle.
Right, I was going to say, so you have
Explains why
I'm very
he's
sorry
feeling
to
rather
accost
bereft.
my lords, but
Yes.
it was only about 5 yards for my clerk to bring the file into court, but somehow something went awry in those 5 yards. Anyway, I have it
And
now.
I had nothing to do with it.
Right.
So
which
page in the
page?
supplemental bundle.
Page 610. Which is part of the procedural rules for the Development Control Committee. And so these are part of the standing orders. So 610, under section 11, deferrals. And what we're concerned with is 11.4.
Yes.
Only members at the present previous meeting will be able to vote. As if it renders the committee inquorate, then the item will have to be reconsidered afresh.
That would mean that it would have to be, another date would have to be set for it to come back. It wouldn't in any way render null, if you like, or some other expression like that, what had taken place in April, or indeed what had taken place in September, but it would have to come back, is that right, to another
well, it would
meeting
have
of
to
the
come
committee?
up. There are
The committee surely couldn't function. Once the number of people who've been present for the whole of each meeting is reduced below 3, that's the end. A new application has to be submitted.
Well, my lord, it wouldn't be new. There would be an application in front of the local authority.
Right.
It would need to be reconsidered.
Yes.
Well, it's right, reconsidered afresh here. What that would seem to mean is actually a restart, so to speak, on the membership of the committee
Yeah.
that attend. That actually has a number of potential consequences. In my lord's suggestion of the chairman walking out, which is probably an implausible scenario, in fairness, but
Why? Well, suppose he just decided not to show up.
well,
Suppose he'd been advised that was the way that he could effectively defeat the application, at least for the time being.
well, I look into two scenarios. One is if the meeting, the item becomes the item becoming in quorum partway through, then that item can't be considered any further at that meeting because it's not because the meeting's not quorum. You'll have to go back. You'll have to, in that case, go to potentially to the committee again with the ability to attend being restarted.
If I may just
Yeah.
come in, it would be the 4 members who were present at the April meeting. Councillors Mukit, Alam, Chowdhury and Qureshi. And indeed, I think Councillor Brady would be the pool of, as it were, the pool of councillors who could be, as it were, reconvened to deal with the application at a subsequent meeting of the committee under the arrangements that are in place, I think.
Well,
The application, as you've said, would still be live, wouldn't it, before the authority? Clearly, it would be there for the authority to determine, but the rules, as they are, would require that composition of the reconvened committee.
well, my lord, it does, that second sentence throws up some interpretive problems because what is meant by reconsider afresh, is it that you restart the clock or restart the membership, so it's whatever the current membership of the Development Control Committee is, who can consider it rather than the limited category, or whether you simply have another go with the surviving pool of 4. And where does that then leave, for example, Councillor Qureshi, who was observing the second meeting but wasn't legally present at the second meeting, whether she can go back into the pool on the third attempt? I mean,
Well, how could she if Rule 11.4 applied?
anyway,
It was
11.4
considered in the walkout situation, as opposed to Councillor Mukit not showing up. The matter has been considered at meeting number 2, maybe for a short time, but it's been considered. Councillor Qureshi was not physically present, therefore she's disqualified.
He's disqualified by the second meeting rather than the first. Absolutely. And my lord, that illustrates some of the difficulties which the council get themselves into by this diminishing rule. And another consequence, of course, is that the committee membership may change, which it did do here, but one of the councillors who was on the committee in April had dropped off the committee by September.
Forgive me, sorry. Is there any evidence that situation postulated by my lord has ever actually happened? Is there any evidence of that?
My lord, that there's no evidence on operation of the law, and there's no evidence in particular as to what has happened if the effect of the rule is that a meeting is becoming quorate, or would be known to be in quorate.
And how long has this rule been in place?
Well, we've not traced it back. It's certainly been in place for some years. It wasn't introduced in the 2021 constitutional revisions.
Thank you.
And my lords, the other part of the provisions to pick up, so we looked at the rules, we just want to pick up the Planning Code of Conduct, at page 598. And 598, paragraph 13.4. So, whilst there's some debate about the status of these, best view is as standing orders, but there's the second part of 13.4. If it's previously been deferred, then the same councillors will be asked to reconsider the application when it's returned to committee. Two particular issues come up on the way that's formulated. One is that as it's drafted, it's all the members who were at the April meeting, even if the Development Control Committee membership has changed in the meantime. And in respect to the point which my learned friend made about discussion, whilst the rules refer to the ability to vote, 13.4 says the same council will be asked to reconsider the application when it's returned to committee. And so certainly a possible formulation, well, in my case, relies on the way it is particularly drafted. A possible understanding of that is that they wouldn't, if they weren't at the first meeting, they wouldn't be able to take part in the discussion as members of the committee, because that's part of reconsideration going wider than simply voting.
All right, did I get this right? Supposing a councillor is present at the 27th of April meeting, and then after the annual meeting in May is not reappointed to the particular committee, but remains a councillor. Are you saying that such a person remains on the committee for consideration of the particular application?
No, well, we don't say that, my lord, because the committee membership is as appointed.
Yes.
The way the council drafted the rules 11.4 can reflect the change to the membership, and that may be one aspect of the quoracy problem. 13.4 in the Code of Conduct refers it to the same councillors. My lord, where this point does, my lord's question about the change in the membership pose acute problems is in respect of the respondent's notice submissions, which is that I won't go into too much, I'll come back to this later on, but that the suggestion that the Constitution has an automatic effect of changing the membership of the committee or creating a subcommittee. And on Mr. Corner's formulation, that constitutional effect, well, we say it simply doesn't do that at all, but it doesn't take into account the fact that the constitution of the committee has changed, the Development Control Committee has changed in the meantime. The Constitution automatically puts the same as members back in. That's not, in fact, how the Council dealt with it, because it dealt with the new membership of the committee and allowing those who had been at the previous meeting. So, well, that's the problem for-
You're not saying that Code of Conduct 13.4 preserves the membership of the committee as it stood on the 27th of April for the purposes of the deferred application.
My Lord, we don't say it does that, because the Code of Conduct does not determine membership of committees. It's the council at the annual meeting usually, and then any appointments in the meantime which do that. Yeah. The problem for my learned friends is that the Code of Conduct sort of ignores that question of the change in membership. And if it's being argued by on behalf of Mr. Cora that some new committee or membership is changed or subcommittee is formed by operation of the Constitution, that doesn't take into account the fact that the membership of the Development Committee changed partway through the year at the council meeting, the annual council meeting. My Lords, I hope that's sufficient on context. What I want to do then is turn to the law, and first of all, the right of members of the committee to vote, which in the context of politically balanced committees, as this is explicit. Go, my Lords, to... does the Court have the authorities bundle in hard copy or...
Certainly I do. Yes.
Hard copy, if it's tabbed...
We all do.
Excellent. If it's tabbed, tab 7. And within tab 7, first of all, please, to page 179. Which is section 15 of the 1989 Act, and that brings in requirements for political proportionality and appointments to bodies which include committees such as these. Which bodies are included is set out at Schedule 1, Paragraph 1, which is 184. There's an ordinary committee of the authority, and that includes committees appointed as this one is under Section 102 of the Local Government Act 1972. And what the proportionality rules require, it sets out a duty in Section 15.3 to divide the seats between the different political groups. 15.5 sets out the principles which are to be applied in doing so. Not all to the same party. A, B, if there's a majority group, it has a majority of seats in every committee. C, that you add up, you take the total number of seats across the council, subject to these rules, and work out an apportionment between the political groups. And then D, for each particular committee, you seek to apportion in respect of the overall balance. So those are the proportionality rules. Now, that's all about protecting the rights of minority political groups so that they have fair representation on committees and ideally spread across all the committees, not just the uninteresting ones. To give effect to that requirement of seats, the seats matter. If the court goes to page 188, in terms of the definitions, it's Schedule 1, Paragraph 4, And at the bottom of the page, seat is defined in relation to section 15. Such a position as a member of that body as, over the page, entitles the persons holding the position to vote at meetings of the body on any question which falls to be decided. So if you have a seat on those committees, including this one, under the proportionality rule, then that entitles you to vote. And of course, that's the particular reason it's there, is explicit, is to protect members against any attempt of minority groups for them to be appointed but not given voting rights. That's a weeds which ought not to succeed anyway, but the legislation makes clear that members of those committees have the right to vote on any question that comes before it. Now, the right of members to vote is, in any event, implicit in the legislation and recognised by the case law. I just want to pick up one legislative reference. If we go, please, to tab 2, there's the Local Government Act 1972, and within the bundle to page 97, which is Schedule 12, paragraph 39.
So sorry, which page?
Page 97, my lord. Schedule 12, paragraph 39. So, subject to the provisions of any enactment, all questions coming before a local authority shall be decided by a majority of the members of the authority present and voting. So it recognises members voting. That is applied to committees by paragraph 44 of the same schedule, which is at page 102 of the bundle. And the right of members to vote is something which has been recognised by the cases, relatively few cases that have had to deal with it, but by the cases over the years. And, my lords, I pick up in the skeleton a number of the older authorities, particularly which concerned a particular incident. I wasn't, unless it would have particularly assisted the court, I'll give the court the references in the authorities, this is maybe a helpful note, but I wasn't going to take the court through the detail of those authorities, unless it would assist.
Well,
but I mean,
you refer to a great number of authorities, some antiquity, and I think we're going to assume that you've correctly summarised them in the skeleton, unless the learned friends want to submit in due course that your summary is a travesty of the authority. So if what you need from a case is in your skeleton,
yep.
I don't think, for the most part, you need to go to the case to prove it.
Yeah. My lord, that's incredibly helpful. The two points that come out of those old authorities are that one of the rights, which is part of the rights of a member, is the right to vote. And secondly, that taking that right away is something which requires clear words in the statute. So those are the 2 points I seek to draw from those authorities.
So you say that the ratio of all this is taking away a member's right to vote requires clear statutory authority.
Yes.
If you had to select one authority to embody that principle, which would it be?
Well, I was going to suggest Queen and Jackson, because that's got the helpful statement by Mr. Justice Ridley, which is at paragraph, page 284 of the authorities, and which I quote at page 35.
Paragraph 35.
Sorry, yes, I apologise, paragraph 35 of my skeleton.
Yeah.
And also within that authority at page 285 of the bundle, Mr. Justice Pickford talks about a member possessing all, that is the chair possessing all the rights of a member and is entitled to vote.
Sorry, the first page reference I missed.
Page 284
Yeah.
of the authorities, my lord, which is 440 of the printed report.
Is it the sideline passage?
Yes, it's yes, my lord. And then the reference to Mr. Justice Pickford's judgment is the following page, page 285.
Yeah.
And it's the right of a member of a parish, the chair of a parish council, having the rights of a member, which include the right to vote.
Notice the presumably obiter observation in the final paragraph of Mr. Justice Pickford's judgment. It is said that the result of our decision will be to make parties equal on this council and thus produce a deadlock, but we have only to construe the provisions of the Act and are not concerned with the result. It then mentions Rowlands.
Of course, my lord, now a deadlock is avoided by the chair having a second or casting vote.
Yes, I mean that's a common arrangement in, if not universal arrangement in local authorities, isn't it?
The second.
The casting vote principle.
Yeah, yes, my lord. It's actually in Schedule 12, paragraph 39.
That's actually embodied in the statute.
So it's embodied in the statute.
So the Jackson case, the result of it remains this day, doesn't it? It's happened in living memory that if the result of a local election is to produce an equal number of councillors between Party A and Party B, the outgoing mayor decides which party is going to be in control of the council.
Yes, remains the position. Now, that the right to vote is implicit in the legislation was recognised far more recently by the High Court in Northern Ireland in the Heartlands case. And I'll just at this moment give the reference to this part of it, and then I'll come to Heartlands more thoroughly in due course.
Yeah.
But it's at Heartlands, it's at tab 13, and it's at page 253 of the bundle, page 11, page 111, where Mr. Justice Schofield, who's the lead judicial review judge in the Northern Irish High Court, says that elected councillors' right to participate in voting council meetings is not addressed directly in the Act rather it is assumed it's an entirely natural assumption. And he refers to the provision of council being present and voting, which is a common provision between the English and Northern Irish provisions. So, my lords, the statute requires there's a right for members to be able to vote. The statute can, of course, take that away, and the court will have seen the reference to members being disqualified from voting if they have pecuniary interests in a particular matter that's being determined, and also if they've not paid their council tax, there's a hangover from disobedience over community charge. The question for the court is whether a council can, by standing orders or by another decision, remove the right to vote. And that does take us directly to the particular provisions in the present case. And so it takes us back to the Local Government Act 1972. And can we go please to section 106, which is at page 74 in tab 2.
Section 76.
Page 100, sorry, section 106, my lord, page 74.
Thank you.
Which is that standing orders may be made as respects any committee. And third line, with respect to the quorum, proceedings and place of meetings of the committee. But subject to any such standing orders, the quorum, proceedings and place of meeting, subject such as the committee may determine. So, my lord, that's first of all a power with respect to proceedings. The issue in this case isn't whether what we're going on is dealing with proceedings. The issue is whether the council can make standing orders which override the statutory rights of councillors. Not whether the standing orders are relating to proceedings, but whether they can override the primary legislation. But, my lords, a point that follows in terms of section 106 is that if the court below, my learned friends, are right that the council can, by standing orders, remove the right to vote, it would follow, because they're dealing with, they would say, as they say, proceedings, it would follow that the committee itself could remove a right to vote without having a standing order, because in the absence of a standing order in section 106, the committee decides its procedure. Now that makes perfectly good sense, of course, the committee deciding its procedure as to how it's going to conduct a particular meeting, especially if there's something relatively unusual happening. But on my learned friends approach, the planning committee, development committee itself could decide either as a general rule or in a particular meeting that councillors in particular categories would not be able to vote. That's the breadth of my learned friends' approach. The other provision on standing orders, which is the one which Joe focuses on, is paragraph 42 of Schedule 12. And my lord, we find that at page 101 of the bundle. And so, subject to the provisions of this Act, a local authority may make standing orders for the regulation of their proceedings and business. And again, as I've mentioned on present and voting, paragraph 44 on the opposite page applies paragraph 42 to meetings of committees.
Sorry, just say that again, I'm so sorry.
So, my lord, paragraph 42 is the power to make standing orders.
Yes.
As paragraph 42 itself is expressed, it's the regulation of proceedings and business for the authority. So perhaps not simply the meeting of the whole authority, but in any event, paragraph 44, paragraph 1, says that, amongst other things, paragraph 42 apply in relation to a committee or subcommittee.
Yeah.
So it's explicit that the paragraph 42 power applies to standing orders in respect of committee meetings.
Seems to be quite an overlap between the last two things you've shown us, section 106 and schedule 12, para 42. Maybe that doesn't
Yes,
matter.
my lord, they both, but perhaps maybe slightly undesirable, but it's not necessarily unusual to have two things which do actually do the same. But they both relate to standing orders. But 106 is authorises the committee to regulate what's not regulated by the standing orders. Now, my lords, in terms of the restriction, the fact that the council can't make rules which overturn the provisions of the legislation, can I go first to a decision of this court, which is Friends of Heffel, and the court will find that at tab 23. That concerned, I hope it's clear in the head note and clear in Lord Justice Sullivan's judgment, but I can summarise briefly what was going on. The council had several area planning committees, so composed of councillors from particular parts of its district, and a district-wide committee. Under section 101 of the Act, it can set out arrangements for decision-making, what are generally referred to as delegations, but the language of the Act is arrangements. The arrangements which it had set up, and those are set out at paragraph 8 of Lord Justice Sullivan's judgment, were, as far as relevant here, that if the members of the area planning committee dealing with a planning application decided to reject the officer recommendation, but did so by less than a 2/3 majority, then the application shall stand referred to the district planning committee. It was automatically transferred to the district planning committee to make a decision on it. The issue before the Court of Appeal was a vires issue as to whether or not the authority had power to make those arrangements because of paragraph 39 of Schedule 2, which we looked at a little while ago, which says that decisions to be taken by a majority of the members present and voting. And the court's conclusion was that those arrangements did violate that provision because a decision would have had to be made by a 2/3 majority to go against the officer recommendation. So that particular provision in the council's arrangements in this constitution was contrary to paragraph 39. Now, it wasn't argued in the case that paragraph 42 on standing orders came into play, but my lords, the point that follows, and the reason why there was no such argument for the council's ability to make standing orders or its ability in Section 101 to make arrangements to override it is the recognition, necessarily implicit in the Court of Appeal's decision, that any arrangements the authority makes have to accord with the rights and provisions which are set out by Parliament and the local government legislation. The council can't choose to set aside the provision that voting is that decisions are taken by a majority, unless the statute provides for a special majority. Council can't set aside the requirement for members to be present and voting. Okay, the Divisional Court held last year that present means to be there. No one suggested the council can just make standing orders to allow members to attend virtually. So the arrangements, standing orders, whatever mechanisms the council then uses for its further regulation of its business, must accord with the legislation. And then, my lords, that does take us most closely to the point in issue, which is the decision of the High Court in Northern Ireland in Hartlands.
So there's no particular passage in Hethel you want us to look at?
Well, the passage which is most useful in Hethel is paragraph 16 and 17 of Lord Justice Sullivan's judgment, page 100, sorry, page 400. Where 16 he says that the power to make arrangements is subject to any express provision in the 1972 Act. Paragraph 39 does make express provision. And he says, the last sentence in 16, paragraph 39 is subject to the provisions of any enactment. It's not subject to provisions or arrangements made under some other enactment, section 101. And then he says, well, yes, the council could have decided that members went against the officer recommendation by a majority, then it would be dealt with by another committee. But what they can't do is to override paragraph 39 by introducing a two-thirds majority requirement in the vote. So, well, that's the, as I might say, as one would expect, the primacy of the detail which is contained within the Local Government Act. Turn then, my lords, if I may, to Heartlands. And the issue in Heartlands is close, but I emphasise the legislation is slightly being debated, slightly different. Here, the Northern Irish planning legislation, which is contained in the Planning Act 2011, Northern Ireland. So just provides for, in section 30, for a predetermination hearing in dealing with when a local authority is dealing with certain planning application. If the court turns, my lord, to page 246 of the authorities, paragraph 85. And we have section 30 elsewhere in the bundle. So certain applications give rise to a predetermination hearing before the committee. That is a separate hearing to the actual meeting of the committee considering the application, although in practice it sometimes occurs on the same day. On the facts of this, of Heartlands, it was actually on a different day and some time beforehand. But that allows persons to make representations, often quite an important hearing, not unusual for leading counsel to attend some of those hearings. What the authority is empowered to do in section 32, that's set out at paragraph 86, is to set out, provide for its procedures for conducting those hearings, and if the court looks at the end of subsection 2, any other procedures consequent upon the hearing are such as the council considers appropriate. The council had adopted a planning committee protocol, references which are over the page at 247, and that underlined by Mr. Justice Schofield at the bottom of 247 included that non-attendance by members at planning predetermination hearing means that members cannot vote on the planning decision. And the question was whether or not that provision was lawful. The Northern Irish local government legislation, which is principally in the Local Government Act 2014, is in many respects similar to the English provisions. There are proportionality rules, but not expressed the same way. Nothing real terms on those. If the court looks at paragraph 80 of the judgment, the reference to section 39 of the 2014 Act, which is the decisions by a simple majority, there is a provision on standing orders, which is contained at section 37 of the 2014 Act. That's not referred to in the judgment in Heartlands. Although, as I point out, quite a few sections in the Act close to that provision are referred to. The court doesn't deal with that. It can't be assumed that the court had overlooked section 37. There's an experienced bench and an experienced legal teams on the case. But in any event, Mr. Justice Schofield is looking at whether there is the power to have that provision. And what he does is, we go to page 253 of the report bundle. Deals with that issue. Paragraph 111, which we've looked at briefly, is the general acceptance is implicit that members have a right to vote. He then refers to two English cases, English or Welsh cases, which I picked up in the skeleton, which are in the court's bundle. Paragraph 114, decision in where the question, as far as the Court of Appeal was concerned, was what advice was given. But that was a question where certain members had not attended a pre-committee meeting site visit. The view which the court took initially in Mr. Justice Collins' judgment, referred to in skeleton paragraph 38 of Mr. Justice Collins, was that it's a matter for the individual members whether to take part, whether they're sufficiently informed to do so, not for the council to prohibit them from doing so. The Court of Appeal followed that same approach, but took the view that the members hadn't been told not to take part. So that was the difference. But that's cited correctly by Mr. Justice Schofield as an authority that it's for the members to decide, not for the council to tell them they can't take part. And then Efferton, where the council had a planning protocol where if there had been an organised site visit, members should decide whether or not, and members who weren't there should decide whether or not they had sufficient information. And that case, Sir Michael Harrison said, well, it's a matter for the members to exercise their judgment as to whether or not they got sufficient information. And again, Mr. Justice Schofield correctly says that that's authority, but it's for the members to decide, it's not for the council to say that members couldn't take part. Mr. Justice Schofield then refers to Armstrong Braun. Again, we have and is referred to extensively in address myself. The issue in Armstrong Braun was whether the ability that the council could adopt standing orders, which meant that to put a matter on the agenda as an item of business for a council meeting, a councillor needed a seconder to do so. So two councillors would need to sign to put it on the agenda. And the council had changed the rules, so simply from one member, simply two members. A independent member said, well, that stops me from being able to put things onto the agenda. And the court there took the view, looking at, recognising that the policy and objects of the Act were important as well as the wording, that there was the power to prescribe how many members need to sign a motion to put it onto the council agenda, but the council had exercised that power unlawfully in the present circumstances by not considering the effect on a lone independent member who doesn't have an ally in a council group who's able to sign up to that. That, of course, is a situation where the legislation doesn't tell you how to put an item on the agenda. So the standing orders would have to deal with that. And, of course, have quite a bit of scope to deal with that, provided that they then carry out lawfully. What Armstrong Braun does do, and it's again picked up by Mr. Justice Schofield in Heartlands, is to emphasise the importance of councillors being able to participate. And I won't take the court directly to it, but there's reference in paragraph 120 of Heartlands to the judgment of Lord Justice Sedley. Helpful for my lords in due course to look at that section from Lord Justice Sedley, so that paragraph 50 to 53, where he emphasises that this isn't simply a question of what the councillors' rights are, but it's the rights of those who have elected them. That the public elect members who are then able to make decisions. Now, turning to the Northern Irish provisions, from paragraph 123 onwards, and I won't read that, will just summarise where it takes us. Well, my learned friend, Mr. Philpott, asked me to draw the court's attention to paragraph 112, of Mr. Justice Schofield, where he refers to procedures as being practical arrangements for the hearing and the conduct of the hearing. The right to vote is not a matter of procedure. But Mr. Justice Schofield's analysis, of course, goes wider in context. His analysis of paragraph 123 onwards. And he takes the view that section 30, the ability to have procedures, is not in reasonably clearer terms were it to affect the right to vote. And he debates over the page in terms of what procedures may mean. I'll leave the court to the totality of that, but his conclusion at 128 is that the provision was unlawful in prohibiting councillors from being able to vote. Now, the learned judge below, in debating Heartlands and looking at the provisions, sought to draw a distinction between what's in section 30, subsection 2 of the procedures. Procedures consequent upon the hearing, and the reference in paragraph 42, sorry, paragraph 42 of the 1972 Act to proceedings. Now, that misses the point both of Heartlands and in the particular case. What we are concerned with is not a question as to what are proceedings. Clearly what was going on at the meeting were proceedings of the council, and the council was standing orders to regulate those. The question is whether the standing orders which they could make, or other committee decisions about how they run the meeting, can overturn a statutory right to vote. So the distinction which the learned judge draws in his judgment between the language of section 30 in the Northern Irish provision of procedures consequent upon the hearing and proceedings does not take us to the point which Mr. Justice Schofield makes, and it's a point which is necessarily implicit in Heffel and in the older authorities, and we might say implicit in the notion of the Act, is that the council, making its own procedural rules, has the ability to do that within the remit which is left by Parliament. And what it cannot do is go against the rights and provisions and regulations which Parliament has put in place. So, my lords, in Heffel, the local authority could not make arrangements which set aside the majority voting provision in section 39. An authority can't allow for virtual hearings where the Act says that members must be present and voting. In Heartlands, the authority could not adopt procedures consequent on a predetermination hearing, which removed from members of the committee their right to vote on the business that comes in front of the committee. In the present case, the council cannot adopt standing orders, which removes from committee members the right which they have to vote by virtue of then being members of the committee, and doubling up in this case because it's a proportionate committee subject to the 1989 Act, members who have a seat on the committee, which the Act says confers a right to vote.
But you accept, don't you, that if a member is 5 minutes late for one of a series of meetings, that's too bad. They're disqualified for all time.
No, my lord, I don't. My lord, I didn't. The position which we've taken this position, it's paragraph 3, paragraph 2, right at the start of the skeleton, has always been the case that there is no power to, by standing orders, to remove the right of members to vote. Where the right of members is removed, to vote is removed, it's done by the Act of Parliament. In terms of the position where a member turns up partway through the consideration of a matter, that may raise different legal issues, which I'll come to in a matter of seconds, but it doesn't allow the committee to prohibit the member from voting or allow the standing orders to do so. The legal issue, which does potentially rise, potentially the two, but the most obvious legal issue is a question of whether the committee, in making its final decision, will have taken into account all material considerations in circumstances where there's the possibility that a member of the committee missed some of the information, some matters they should have taken into account. That is a situation which is very similar. I'll explain how it's dealt with practically, and can be dealt with practically in a moment. But that's a situation which is very similar to the issues dealt with in the Ware and Efferton cases, where members have not attended organised site visits. They can't then be banned from voting for the members to make a decision. There will be, potentially, a question as whether or not the committee decision which follows is lawful, because the committee has to take into account all material considerations. But that doesn't stop the members from deciding to proceed. It may affect the lawfulness of what results. Now, the lawfulness of the decision in those circumstances will depend on the circumstances, and one can postulate two relative extremes in the context of a committee meeting. One is where half of the committee turn up just before the vote's taken, after an extensive debate and after hearing members of the public and the developer making representations, turn up and then stick their hands up in a particular direction. In that situation, the court is perhaps very likely to conclude that the committee haven't regard to material considerations, there's a possibility of predetermination, and they've not acted fairly. Another situation, probably the more common situation in practice if these problems arise, is where a member turns up partway through the introduction to an item. And our Lord Senior President, I know we're very familiar with this, but if Lordships may help us with this explanation, what would tend to happen when an application is dealt with, particularly an application of any size, is that an officer will, at the start of the item, explain what it's about. Members will already have had the committee report, but there's likely to be a presentation by the officers, which is partly going to be explaining what's already in the report in reality, and then updating on any new material, and the members may also receive a second written update. There's then, very likely as a matter of practice, or there's no legal requirement to do this, public speaking and speaking from the applicant. Members of the council who aren't members of the committee may then speak, very usually, and then the committee will question the officers and discuss it and then reach a conclusion. Now, if a councillor turns up 5 minutes into the officer's introduction and the officer has said nothing new that isn't already in the report, then in those circumstances, there'll be no question that the decision that results at the end of the day will be not rendered unlawful by that. That member will have known everything which he or she needed to do, and that can be clarified there. But those are issues potentially as the lawfulness of the final decision. What it doesn't permit is to have a prohibition which is not in the statute. Now, in practice, if a member turns up late, it may be checked, well, have they missed anything? Let's just absolutely clear the member knows as much as the rest of the committee. Or it may be that they receive advice that, well, you may have missed something you needed to know, and we'll advise you not to take part in the decision. Members are very likely to accept the advice they're given. But let's assume we get to the position where, following the meeting, there is an issue of this sort. The member wasn't there, they don't know. In practical terms, the decision of the committee is only given effect by decision notice being issued. If there is an issue about the lawfulness of what happened and it's raised before the decision notice is issued, then the council will take advice, and quite possibly in those situations it will come back to committee next time. But none of that requires the council having the power to ban members from voting. None of that necessarily leads to the committee decision being unlawful. It depends on the circumstances, and it can all be resolved by other means. What the Ware and Efferton and implicit is in Heartlands recognising is that the members who are the council have to then make decisions what to do, and then the lawfulness of that decision gets taken later. What doesn't is for the right of individual members to vote to be taken away. And this perhaps goes to really sort of the fundamental points which arise in the case, that we are dealing here with a vital part of our constitution and of local democracy, a part which involves councillors being elected. So their ability to act is not simply a question of their own rights, their own office, but their ability to do what the electorate have put them in to do. And where a council operates by usually majority voting, but it is not a system of government where the majority gets its way regardless. What I mean by that is that council decision making is one which involves either all the councillors together, or it involves the council on the committee, or the council scrutinising an executive. It involves those who are in the minority groups as well as in the majority. It involves an ability of councillors to take part in that decision, whether they are instituting debates and forcing votes on matters which they are going to lose. Just stepping aside, because we necessarily in this case are looking at the issues generally as a power, not simply in terms of planning terms, but in terms of the party political issues. Those members who are in the minority parties have the same right to vote as the majority. And it's not for a majority or even the council by unanimity, even acting for good intentions, to take away the rights of councillors. Whether that's to take away the rights for good reason, or take away the rights of the the awkward squad, or simply as in this sort of situation, to take away the rights of members who were not on the committee on one occasion, have been appointed subsequently, or weren't at one meeting, and come to the meeting subsequently.
Can I just be sure of this then? It's a prominent feature of Mr. Philpott's skeleton that you accept that Rule 5.4, in order to be able to vote on an item, the councillor must be present throughout the whole of the committee's consideration, including the officer's introduction to the matter. He says you accept that there's nothing wrong with that, therefore you have no case because it's impossible to distinguish the two rules. He is wrong, is he, to say that it's common ground that Rule 5.4 is okay.
That's correct. The point which my learned friend alights on is at page 67 of my skeleton.
Yes.
Which is at page 62
Paragraph
of
67.
the core bundle. If, of course, I'll have it there, but it's page 6, paragraph 67. Skeleton, page 14 on the internal numbering. And having set out my submissions, which were that paragraph 42 doesn't enable the right to vote to be removed. I pick up 2 points mentioned by the judge. One about constitutional direction and the other is about members coming in partly through. And what I say, and I think this is where my learned friends are coming from, is the third line, position is different from the present case, and then saying that maybe lawfulness issues. Now, what I could have said is also the position is different. There are lawfulness issues there. Now, my lord, our analysis is that, in line with Ware and Efferton, is that the potential unlawfulness of a decision following the way in which a council is taking part in the meeting doesn't allow the council to be prevented from voting. But if there was going to draw a distinction, that would be the distinction. But my lord, all I do is draw attention to the potential lawfulness issues there. Our case, that there's no power to remove the right to vote, is set out, I say repeatedly in the skeleton. There is paragraphs 3.2, which is a summary, 35, 36, 39, 41, 56. My lord, paragraph 67 I could have expressed more clearly, saying as sort of additionally the position is different. But my lords, our position has at all stages been that there is no power to remove the right by standing order, to remove the right to vote.
You distinguish between the councillor who turns up 5 minutes late, in effect misses nothing, would be excluded under Rule 5.4. You say that that's unlawful, although it's not what happened in the present case.
It doesn't arise in this case.
The councillor who misses most of the discussion turns up at the last minute to vote. The decision may be unlawful at common law, so to speak, yes, not irrespective of Rule 5.4. Yes,
my lord, okay. because of the argument that the committee had with regard to all material considerations, amongst other things. And yeah, that will depend. In practice, the likelihood is that advice will be given, likely to be followed, and it may well be that the committee will reconvene to consider it again when everybody's turned up promptly. So there are ways of dealing with those issues in practice. But it's not for even the chair of the committee to decide who can or cannot vote, unless, of course, the legislation has prohibited them from voting because they've got a pecuniary interest. So, my lords, it is a question of price and the stepping stepping back to look at the local government, if my learned friends are right, then the various provisions in the Local Government Act which regulate proceedings, simple majority, present and voting, the need for minutes, and so on, are all unnecessary because the local authority can do something different by standing orders. All that will be done is for the Act to say that local authority will regulate its own proceedings. What Parliament is doing when it does say what rules are, what provisions are, is setting up things which authorities must comply with, which they can't choose to adopt an inconsistent procedure.
Does it come then to this really, that the right to vote is sacrosanct, save where there is an express or explicit statutory exclusion of it? That's the proposition.
Yes, my lord. And that is something which flows not simply from Parliament having set out various rights and then a general power to the authorities to decide this procedure, but flows from the working out of those rights. And I'll just draw attention back to the questions of proportionality, which do arise in this committee. The purpose of the proportionality rules is to enable minority political groups to be represented on council's committees with a spread across the committees as well. That requires, as we looked briefly at section 15, requires the council to, in fact, do various calculations. It needs to think how many committee places there are in this pool of relevant committees, work out how many committee places the split of the party groups across the council would then give, and then seek to allocate committee places to keep a majority for the majority on each committee, get that overall number right across that pool, and to try and get a balance between the parties on each individual committee. Now, that involves the council making a decision that's relevant to two purposes here. First of all, in respect of the primary case of the appeal, if the council constitution prohibits various members of a committee from voting on a particular item, then that unravels the proportionality in respect of that item, because members are excluded on a basis which doesn't relate to proportionality at all.
Well, it might do. It has the potential to produce a distorted membership or disproportionate membership.
Well, it would distort it in some fashion. How significant that is will vary. Now, obviously, there are some situations where the statute excludes a member from being able to vote, and that will almost be taken as part of the context. That just happens. The other aspect of proportionality in decision-making relates to the respondent's notice point. And if it's helpful to the court, I'll go and deal with the respondent's notice point in opening. But on this aspect of proportionality, a decision to establish a new committee or a committee with different membership or establish a subcommittee triggers the proportionality rules because it changes the number of councillors who are council seats which are in the pool. The council would have to decide what then the overall allocation of seats would be, and it would also, within that overall allocation, seek to ensure that the new committee was balanced between the particular parties. All of that involves conscious decision making and also a little bit of number crunching to get to that point. Now, the case which council and the interested party were advancing in the court below, and which the interested party pursues by respondent's notice, creates a development control committee with a different membership or a subcommittee automatically, without anyone carrying out that exercise of working out what the membership would be and what effect it has on proportionality across the council committees. And that's something which simply cannot be done. That is one of a variety of reasons why the respondent's notice point is bad. I'll take it relatively briefly because the learned judge rejected these points, the new committee, new subcommittee arguments by the council and the respondent in pretty strong terms, and was right to do so. But to put the points very briefly, the Constitution doesn't purport to change the membership of the Development Committee. Mr. Philpott's intervention earlier was to the effect that what the rule does is stop particular members of the committee from voting. They're still on the Learned Friends analysis, members of the committee, they just can't vote on that particular item. It doesn't purport to set up a new subcommittee. What it does is, ought to do is what it says it does, which is to prohibit them from voting, and the code says they can't consider the application. Now, the council, if it chose, could establish another committee to deal with deferred applications, or establish a different committee to deal with a particular application. But that does involve a conscious decision, involves a resolution, it involves dealing with proportionality matters, and it involves establishing a development Truman's Brewery subcommittee if it's a particular application, or some other form of the development committee. None of that was done.
Well, that's all right, is it? Others in the court will know more about this than I do, but 27th of April, the application is deferred. Consideration of the application is deferred. It would be lawful, would it, for the council to resolve that further consideration of that application should be by a new committee consisting of councillors A, B, C, D, E, and so on.
Yes, my lord. They could make that decision. They would have to, in terms of the committee, would do it as a subcommittee, but they still have to apply proportionality, and they'd actually have to make, more importantly, make a conscious decision to do it.
Yes.
And that's what didn't happen. And those.
How does that sit with the right to vote?
Sorry, my lord.
I'm so sorry. How does that sit with the right to vote?
It fits with the right to vote because an authority can decide what arrangements it makes. So it can decide to set up a particular committee to deal with a very particular matter. The members of that committee will have a right to vote. So it doesn't compromise the right to vote. And that perhaps is why my learned friend wasn't below, but why the council and Truman Brewery went down this route of trying to argue that there's a new committee or a new membership committee or a new subcommittee, which is that is a potentially permissible route rather than simply taking away committee members' rights to vote. But their problem is it didn't happen. It's not what the Constitution provides. And also, it's not actually what happened in practice. The court probably appreciate there are provisions for giving of notice of committee meetings and the making available of agendas and production of minutes. So the provision for the notice, I'll just give my laws the reference, I don't need to turn them up, but in the Local Government Act 1972, section 100A, subsection 6, requires notice of meetings to be given, and section 100B requires agendas to be made available, and by section 100E, those requirements apply to committees and subcommittees, as well as to the main council. So what would happen is that there would be a notice of a meeting, an agenda, which would say a subcommittee would give the new member, would say committee and give the new membership, the Learn Friends analysis, or say this is a subcommittee with whatever the membership is. Now, none of that happened. We had the meeting, the chair, the court will have seen, reads out at the start of the item a statement which officers have drafted saying that members who hadn't been at the previous meeting couldn't vote. No one at that meeting suggests that the membership of the committee is changed for that item, nor do they suggest that this is a subcommittee. The minutes of the meeting don't suggest that there is a different committee or a subcommittee, or that partway through the meeting the composition of the committee changed or turned itself into a subcommittee. No one, whether they're councillors or officers or the developers team, have said that they thought they were attending a meeting of the Development Control Committee with a membership adjusted in this fashion, or that they're attending a meeting of a subcommittee of the Development Committee. The submissions which are fiction, because it's not what happened. What the respondent's notice point is seeking to do is to try and to put a potentially legitimate means of making the decision by different council, a narrower group than the Development Committee. A potentially legitimate means forward of forming a different committee or a subcommittee as the explanation. But they're doing that in circumstances where that simply didn't happen. So Mr. Justice Morris was quite right to dismiss those two grounds of resistance to the claim which were being made. I do suggest, and of course it's the advocate's prejudicial point, but I'm going to make it anyway, that the reason those grounds were advanced, and the reason that the developer still advances them, is because the point on which they were in front of Mr. Justice Morris, of simply relying on the standing orders to remove the right to vote, was an inherently poor point. The obvious way of dealing with the legislation respecting the rights of councillors is that where the legislation gives a right to vote, it's the legislation which has to take it away. And the council, whilst it will deal with many matters in its standing orders, is not able to use its standing orders to overturn rights and requirements which are contained in the legislation itself. Those standing orders operate, they are expressly subject to the rest of the 1972 Act, they operate within the requirements and the powers and the rights that Parliament has prescribed. None of that creates an insurmountable problem, or even a great problem in the present sort of case. Lawful decisions can be taken, and yes, it might be rational to take a different approach. Say if you weren't at the first meeting, you can't take part in the second. that Parliament has taken the view as to who may vote, the power when the right of members is taken away. Parliament has taken the view that members of a committee have a right to vote. Perhaps it may, in isolation, be rational to do something different. It's neither here nor there when Parliament has legislated. And as cases like Heffel and Hartlands illustrate, there are some hard rules. There are vires questions as to what procedures can be adopted. And as in Heffel and Hartlands, this is one of those situations where the council has adopted a process which it had no power to do. It's a question of law, it's a question of vires, it's also in that context a question of how democracy works, powers of councillors and the rights of those who elect them to make decisions. But, my lords, unless I can help any further, those are all my submissions now.
Thank you very much, Mr. Yes, Mr. Phil.
Please, Your Lordship, if I just take a moment to arrange my...
Of course.
My Lord, what I propose to do by way of a structure of my submissions, I've got some introductory points that I want to deal with first. I'm then going to move to the issue of statutory construction that arises in this case. I'll then deal with the proportionality issue. Then, so far as I need to deal with the authorities, I'll deal with those at next. And then finally, some concluding points. So, my Lord, if I might start my introductory comments, that we say this appeal raises one main question, and it is a question of statutory interpretation. And if I can ask your lordships to look at the council's skeleton argument. So this is in the core bundle and at page 68.
Yes.
Your lordship will see a summary of the council's case, and the first subparagraph identifies what we say is the determining issue here, and that's whether the words regulation of their proceedings and business in paragraph 42 of Schedule 12 empowers authorities to adopt standing orders that restrict voting on deferred planning applications to those members present at the original committee meeting. We say that is the correct framing of the issue, and if I can then ask your lordship to turn on to page 77 and to paragraph 37, where the first sentence picks up the points summarised at the beginning, and then we say this: if those words are broad enough to encompass a restriction on voting, the relevant provisions in the Constitution are intra vires, and we say the appeal must be dismissed. In other words, we say that question is determinative, ultimately, of the appeal. Now, Lord, as I'll go on to explain, our case is that when one looks at those words in context, they are clearly apt to authorise adopting such a restriction, and that when they're looked at in their full statutory context, that only reinforces the initial impression formed when reading them within the scope of paragraph 42 itself. And whilst that formulation of the issue in our skeleton argument reflects the specific facts of this case and the particular provision within the Council's Constitution at paragraph 11.4 that's been called into question, we say the court can't ignore the wider consequences of the argument that the opponent is running. That's something that's just been touched on recently under the clarifying the position in paragraph 5.4. Now, on that, deal with that briefly at this stage, and I'll come to deal with it in more detail in due course. We say Mr. Justice Morris was right to consider the relationship between the paragraph 11.4 provision and the paragraph 5.4 provision, and that we'll come to it, that that's at paragraph 125 of the judgment. And until today, we say the appellant has never sought to argue that the paragraph 5.4 provision is also ultra-vires. Now, I should say at the start, my case doesn't depend on whether the appellant has changed its case or whether 5.4 is said to be ultra-vires or not. So it's necessary for the court to consider it. My case remains good, whichever way the appellant jumps on this. But I would just say this, the point that is, as your Lordship has correctly identified, prominent in my skeleton argument, is not a point of my invention. It's a point that was raised before my involvement in the previous pleadings and arguments in the case. And if I can just identify briefly, in the core bundle, at page 27, this is within the appellant's skeleton argument seeking permission to appeal. At paragraph 58, one finds the same point being made as is made now in paragraph 67 of Malone and French skeleton argument for the substantive hearing. Paragraph 58 refers to the paragraph 5.4 rule and says the position is different to the present case and seeks to distinguish the paragraph 5.4 rule from the paragraph 11.4 rule. That did not go unnoticed by those representing my client and also the interested party. If I can ask your Lordship then to go to the bundle at paragraph, page 032. This is the counsel's response. Paragraph 3 on page 32, about halfway down the paragraph, the appellant recognises that standing orders can remove the right to vote in the first of those circumstances. Footnote 4, paragraph 58 of the skeleton argument. And the same point is made, I don't think your Lordship to turn it up, but by the interested parties, that's core bundle 36, paragraph 4a. That is the context in which, in the skeleton argument for this hearing, paragraph 67 is repeated, repeating what was in paragraph 58, the appellant maintaining its position, not suggesting that the counsel or interested party had misunderstood its case. The final reference, your Lordship may have seen in the submissions made on behalf of the appellant seeking to resist the evidence that's in Appendix C, that one of the grounds for seeking to resist that was that this related to what was said to be a different point. And so this is in the unagreed bundle, page 698, paragraph 6. And the point made at paragraph 6 is that our application doesn't in fact address the Tower Hamlets type provision. And then the third sentence, the application is on a different point, where the local planning authorities have made provisions about members who are not present at all at the final meeting on the application. And this is only one example, refers to attendance at previous meetings. Now, of course,
what are you asking us to do, Mr. Phil?
Sorry, my Lord?
What are you asking us to do?
Well, my Lord, the simple point is to recognise this, that the very fact that this has changed as what I describe as a volte-face is indicative of the appellant's lack of confidence in its case and recognition, belatedly, that its case goes wider than either falls away altogether because it has an internal logic which doesn't work, or necessarily goes wider. And so far as your lordships are concerned, this is where the point then has resonance, because the logic of the appellant's argument now is not just that it would take away the paragraph 5.4 rule as well. If the appellant's right, any other rules in councils' constitutions which prohibit voting in circumstances that are not specifically authorised by statute would be ultra vires.
Yes.
Now, my lord, there are I'll give your lordship the references, we don't need to turn them up. There are two such provisions which happen to be in the bundle before your lordship. There's one dealing with actual bias by members, which is at supplementary bundle, page 585, paragraph 2.5.
Sorry, reference again?
Yes, it's supplementary bundle, page 585. Paragraph 2.5. Requiring members to withdraw from considering the application, and then 588.
This is planning code of conduct.
Yes, paragraph 3.7. Councillor with a personal interest which might appear to a fair and informed observer as a real possibility of bias must not participate, and then at the bottom of that paragraph must withdraw from the room for the rest of that item, take no further part in the discussion or vote. Now, my learned friend raises a question of whether that is or is not a standing order. I suspect that's not determinative, but the fact is it would also prevent councils from adopting any such rules. So a councillor who's found to be actually biased or to have the appearance of bias could not be excluded by standing order.
Well, just a minute. That seems to me that's quite a profound submission. Rule 2.5, Code of Conduct 2.5. If a councillor considers they do have a bias or cannot be impartial, then they must withdraw from considering that application. Who decides that?
Well, my lord, in that case, it's the councillor who decides, but it's the rule that if they think in those circumstances, they must not participate. So it is if the position of the opponent is right, if the councillor comes to that view, it would be ultra vires for the council to say, well, in those circumstances, having come to that view, you must not vote. You would have to leave it to the judgment of the councillor, whether notwithstanding that they've arrived at that view, whether they vote or not. But it illustrates the point.
Well, the chairman can't say you're biased, but you leave the meeting, the
It would
security
have
man
to
will
be
drag you out.
that is the view of the individual councillor.
Yeah.
And if that's right, on my learned friend's case, it would have to be left to that councillor, having reached that view, to decide whether or not they should vote. You can't have a standing order that says, well, once you've reached that view about your own position, you must not vote. So Lord, the point is not just a forensic vote, it goes to the wide consequences of my learned friend's submissions. Now, in each of those cases, either the ones that I've just drawn attention to or the ones we're dealing with through paragraph 5.4 and paragraph 11.4, the underlying public law rationale for the rule in question is obvious, and we say it's a sensible and proportionate provision. But the appellant's case is that notwithstanding that, the words that Parliament has used are not broad enough for any such rules within standing orders. Now, we say that when one looks at the words that Parliament has chosen, properly understood in their statutory context, that's plainly not right. That's our case. Now, my Lord, the next point I want to make by way of introduction is in relation to the democratic principle. It's the appellant's argument in support of its case that councils can't make such eminently sensible and reasonable rules to regulate their proceedings relies on the entitlement of elected representatives to make decisions and thus engages the democratic principle. But we say in this case the democratic principle cuts both ways. The first point, it's important to keep in mind that the voting provisions here have not been imposed on the elected members of the council. Through Schedule 12, paragraph 42, Parliament has entrusted the task of making standing orders regulating the proceedings of local authorities to the democratically elected members of those authorities. And the provisions in issue in this case are ones the elected members of the council have themselves voted to adopt as part of the framework for the carrying out of their functions. And your Lordship will have seen that the relevant decision-making process for the adoption of the Constitution is summarised by Mr. Justice Morris at paragraph 19 of the judgment. That's page 134 of the core bundle, but that's not, there's no issue about the facts there. And the exercise by local authorities of that power to regulate their own proceedings in that way is, of course, subject to the supervision of the courts by way of judicial review. Now, in this case, the elected members of the council have voted to adopt a scheme of regulation of voting, which is not in doubt or dispute that it has a clear and rational basis. It's consistent, we say, with well-established principles of law requiring decision makers to listen to all the advice, submissions and evidence before making up their minds and voting. And the appellant does not argue that those provisions would be unlawful if they're within the scope of paragraph 42. Now, in effect, the appellant's argument is that notwithstanding the widely expressed power that Parliament has bestowed on local authorities through the Local Government Act, it's nevertheless retained for itself the exclusive power to regulate voting. We say the words that Parliament has used simply don't reflect that. I'll just pause there, my Lord, to note, during my learned friend's submissions, it did not appear to be suggested that the word proceedings, the paternisation, is not apt to cover voting. The point seemed to move away from that, but I nevertheless will come back to the actual words that are used and reflect on what they say and also how they relate to the words the court was considering in the Hamlets case. The second point, my Lord, about the democratic principle here is that it is directly engaged by the purpose of the paragraph 11.4 provision and also paragraph 5.4 provision. My Lord, if I can ask your Lordship to look at our skeleton argument, page 79 of the bundle. And this is a continuation of paragraph 42, which starts on the preceding page. And in subparagraph 3, we explain how we say the provisions are intended to give effect to the principles that have been enunciated in cases such as Island Farm. You'll see we refer to the Island Farm case at the bottom of page 79. And can I ask your Lordship just to turn up the Island Farm case, which is in the authorities bundle at tab 24. So, my Lord, this is a decision of Mr. Justice Collins. The part that we rely on, we've referred in our skeleton argument to paragraphs 31 and 32 on page 419. But for the purposes of my submission, I want to go back to page 416 to where Mr. Justice Collins was gathering together the relevant legal principles from previous authority that he later summarises in paragraphs 31 and 32. And I want to draw attention in particular to paragraph 26 at the bottom of page 416 where reference is made to the Bovis Holmes decision of Mr. Justice Ouseley. And, my Lord, at the bottom of the page there is paragraph 112 within that quotation, where it's noted that there is an overlap between the requirement that's dealt with in the previous paragraph, which is to do with consideration of weighing of relevant factors, taking account of relevant material. Sorry, an overlap between this requirement, the predetermination requirement, I've got this wrong way around, paragraph 11, and the requirement to have rational regard to relevant considerations. But in my judgment,
I've lost you. Which
yes,
paragraph?
It's paragraph 26 at the bottom of page 416, and I should have introduced perhaps paragraph 111 first, where Mr. Justice Ouseley talks about predetermination.
Yes.
He then goes on in paragraph 112 to say there is obviously an overlap between this requirement to avoid predetermination, and the commonplace requirement to have rational regard to relevant considerations. But in my judgment, the requirement to avoid predetermination goes further. The further vice of predetermination is that the very process of democratic decision-making, weighing and balancing relevant factors and taking account of any other viewpoints which may justify a different balance, is evaded. Now, my Lord, we say that that is the issue that the provisions that are in question in this case are intended to address. It's both taking account of relevant considerations, and as my learned friend appears to accept, predetermination. Because if to take the extreme case, if a member comes in just before the vote, hasn't heard anything, casts his vote one way, well, it would appear, on the face of it, a strong case for predetermination. So that is an important part of democratic decision-making to avoid predetermination. And that is undermined if members can vote without the need to attend, listen to what people say. And our case is that councils have been empowered by Parliament to adopt standing orders which allow them to stop that from happening in a perfectly proportionate way.
Of course, you could still have predetermination in other circumstances where there wasn't this restriction.
Yes, predetermination could arise in a sense no matter what rules one puts in place to deal with it. The issue here, we say, is that the rules that we're dealing with are intended as a proportionate practical measure to deal with issues such as predetermination and whether or not members have in fact taken account of material considerations and have, as I think we pushed in the discussion, exposed themselves to the possibility of being persuaded one way and another. And our case is that when you look at the words that Parliament has used to give this power to local authorities, that it is plainly wide enough to allow them to do that. We say it's entirely unsurprising that that has been entrusted to the democratically elected members to determine for themselves. Otherwise, I was then going to turn to my first main heading, which is the issue of statutory construction.
Yes. Before you do that,
yes.
Mr. Philpott, I apologise. I should maybe have asked Mr. Harwood this, but I dare say you all know this by heart, and I don't. What are the statutory exclusions of councillor from voting? You can't vote if you fail to pay council tax, so that's not very relevant. And then Mr. Harwood mentioned pecuniary.
Yes, my lord.
Interest.
There are two, and I think my learned friend did pick up both of them. There is in the one goes to the authorities bundle, tab 10. Tab 10, section 31 of the Localism Act 2011. This deals with pecuniary interests,
I'm very sorry, could you give me that page reference again?
It's page 210 in the authorities bundle behind tab 10.
So that's pecuniary interest.
Yes, and subsection 4 identifies that members who have a disclosable pecuniary interest may not participate and may not participate in any vote. And then there is the Local Government Finance Act, which is a couple of tabs back, tab 8. This is the one that deals with council tax and community charges.
And those are the only ones.
As far as I'm aware, my lord, those are the only ones. And our case is that Parliament has left it to the councils and their judgment as to whether any other circumstances may justify any restriction on voting. In other words, we say those are the ones that are obligatory, they are set by primary legislation, but the Local Government Act allows councils to that the power is broad enough to encompass restrictions on voting. So, Lord, if that's enough on that particular query, I'm not aware of any others I can draw attention to. If I can start with my skeleton argument, core bundle page 81, we address the meaning of the words proceedings and business in the Local Government Act from paragraphs 46 through to 45. The approach to that exercise, we have...
Sorry, 46 through to
55.
55.
And the approach to that exercise, we say, it is, as summarised by Lord Hodge in the O versus Home Department case we've identified at paragraph 46. I don't understand from what my learned friend has said in submission that he takes issue with that, or could do, as the approach to statutory interpretation. Now, my Lord, what I'm going to focus on in my submissions, and I've focused on in these paragraphs of the skeleton, are the relevant provisions of the Local Government Act 1972 itself. But once I've dealt with that, I'm also going to need to touch briefly on what we've addressed in our skeleton argument at paragraphs 32 and 33 and footnote 8, which is the Local Government and Housing Act 1989 and its relationship with the Local Authority Standing Orders England Regulations 2001. So I'll come to that once I've dealt with the Local Government Act. So, my Lord, if I can then start with the Local Government Act, we say that the key word within paragraph 42, schedule 12, for present purposes, is proceedings. And we say in the present context, at least, business relates to the substantive matter being voted on. It's proceedings that we refer to and rely on. And the most directly relevant context within the Act itself is provided by Part 5 and Schedule 12, to which it gives effect. So if I can ask your Lordship to take up the Authorities Bundle tab 2, which is the Local Government Act. And I just start, my Lord, on page 46 with section 99 of the Act. It's entitled Meetings and Proceedings of Local Authorities, and this gives effect to the provisions of Schedule 12 with respect to meetings and proceedings of local authorities and various other bodies. So,
I'm so sorry, which section was it?
It's section 99, my Lord, on
99,
page 46.
sorry.
So this sits within Part 5 of the Act. And your Lordship can see that the relevant part is identified in italics underneath the provision in each case. So it sits within Part 5. And Part 5 itself has a heading which we say is relevant, and that's most clearly seen just in terms of the printing format in the original version which we have at tab 3, so as enacted at page 104. General provisions as to members and proceedings of local authorities. So that tells one that that Part 5 is dealing with provisions for members and proceedings, and we say in that context it's highly relevant that as originally enacted it included restrictions on voting by local authority members. So if one goes within tab 3, so this is the original version of the Act, and turns through to page 114, there is a heading just above section 93, restrictions on voting. So part 5, dealing with general provisions as to members and proceedings, includes restrictions on voting, described in those terms. Now, my Lord, at that time, the restrictions, one can see section 93 was a restriction on voting by GLC councillors in certain circumstances. The precise circumstances, in a sense, don't matter for present purposes, but if your Lordship looks at 93A, for example, one gets a flavour of it. It's to ensure people are only voting when it's appropriate for them to do so, having regard to what's being dealt with. And
94 and 95 seem to be pecuniary.
Yes, indeed. 94 was the pecuniary interest. That's since repealed, and your Lordship's seen how that is subsequently dealt with in other legislation. And then what follows in 95 and 96 and 97 are provisions which are dealing with ancillary matters arising from section 94. So 95 defines pecuniary interests, 96 governs disclosure of such interests, and 97 allows for the section 94 restriction to be lifted in certain circumstances where it effectively creates administrative obstacles, and then section 98 deals with interpretation. So, my Lord, that we say is highly relevant to the breadth of the word proceedings as used by Parliament in this part of the legislation. And my Lord, in our skeleton argument, we deal with Schedule 12 in particular at paragraph 49, which is on Core Bundle page 82. And we draw attention there to the fact that Schedule 12 itself contains further provisions regulating who may vote and in what circumstances. So we've provided a list there in parenthesis. My Lord, I can either take your Lordship through them in the bundle, or I could
go
provide
back
now.
to your paragraph 28.
Well, yes, and my Lord, I've what I can do, if I can just briefly summarise and give your Lordship the reference to what they do, and then if over lunch your Lordship thinks it's worth me going back to them, I'm happy to do that. So paragraph 6ZA, which is on page 89, it is voting by a relevant police and crime commissioner. Paragraph 16, page 91, is voting.
Could you just, if you're giving us the page numbers,
yes,
be very helpful. 6ZA is
page 89.
Thank you.
If I'm going too fast, I apologise.
No, that's fine. I'm going too slow. 16 is page...
16 is page 91.
Thank you.
That is voting by the chairman of a parish council at a parish meeting. Paragraph 18 is on page 92. That's voting by local government electors at a parish meeting. My lord, my understanding is that a local government elector is simply someone who's entitled to vote in local elections. We can trace that back. Paragraph 31, which is on page 31, that's voting by a chairman of a community council at a community meeting. And then paragraph 34, which is on page 95, is voting by a local government elector at a community meeting. So, my lord, the simple point we make is that when the phrase regulation of their proceedings in paragraph 42 is read in the context of the relevant group of provisions of which it forms part, it's clear, first of all, that those provisions treat voting as being within the scope of the word proceedings, and thus that regulation of their proceedings is wide enough to embrace the regulation of voting. When we say there's no proper basis for giving the word proceedings in paragraph 42 a narrower meaning than it has elsewhere in the relevant group of provisions within the same legislation. Now, my lord, I was then going to move on to how Parliament itself uses the term. I can either deal with that before lunch or afterwards.
Unless it's a 2 or 3 minute point, shall we? We can break off now. But
let's break off now. I don't want to rush it.